All rise. Please be seated. Kathy Smith and Theodore Visnor, case number 10-23064.
Good afternoon, Appearance Counsel, please.
Bruce Havens, Your Honor, here on behalf of the creditor, Shelley Sweet.
Good afternoon, and ma'am, good afternoon to you.
Leslie Honig, Your Honor, on behalf of the debtors, Theodore Visnor and Kathy Smith.
Good afternoon, and folks, good afternoon to both of you. Mr. Havens, this is your motion, so I'll let you proceed with it.
Thank you, Your Honor. I appreciate your calling it a motion. We took a very circuitous route getting here. It was a strange route, largely of my creation, or all of my creation, frankly. The first time I got involved in this case, Judge, was about a week prior to a closing that was scheduled on this property on the 30th. Ms. Sweet, I've known her for a long time, and she stopped in my office, and I was with a client. She gave me a file, indicated what her problem was, indicated that the folks had moved out. I grabbed her file. I said, let me take a look at it. We'll figure out what we can do to get your property sold. I looked at the file. When I looked through the file, I found that there had been an action filed in the Isabella County court system to evict the tenant from the property after the bankruptcy had been, or excuse me, there was nothing in there that indicated when it had been filed at that point in time. Subsequently, I found that the notice to quit had been served well before the bankruptcy had been filed, but it was just a couple of days ago that I found out that the actual complaint was filed in the district court after the bankruptcy had been started. In any event, there was the file that I received had a copy of a judgment of eviction. It had been entered after the bankruptcy had been filed. Ms. Sweet had told me that Ms. Honig had been there and was representing the debtors but didn't make an appearance in the case. My assumption was at that point in time, because it was my understanding the property was vacant, that she didn't have any objection to the court continuing to hear the matter. In any event, I chose to file this action the way I did because had I followed any other method, it would have required notice and a 14-day hearing, or at least a 14-day opportunity to object, in light of the fact that there was a different address on the petition. The party had testified at the 341 hearing that they didn't live there. The statement of intention on the paperwork showed no intention regarding the property. I thought the safe course of action, in order to try to expedite things, because I didn't believe that the debtor had any interest in the property, particularly in light of the realtor's letter. I guess, Judge, I'm relying on the fact that you've looked at the paperwork. I know you're very good at that.
I have looked at the paperwork, Mr. Havens, and so far everything that I've seen is supported by what you're telling the court in terms of the timing.
All right, well, then let me shorten things up, Your Honor. I filed a notice basically as a prophylactic method of giving the parties notice. There was an objection filed late on Friday, which I did not get and did not tell my client about. She took possession of the property. There was stuff there. At some point in time during the week, she called me and the police were there, and I found out that the debtor had filed a motion to set us, in district court, had filed a motion to set aside the judgment of possession. I told the officer on the phone, well, there's a hearing apparently scheduled on that tomorrow. Why don't you just tell everybody to go home and go to court tomorrow? He said no, that She had a valid order of possession, so I told Shelley to give the keys to her and walk away, and she did. And I expected the hearing to be held tomorrow. Well, then somebody, I don't know if it was Ms. Honig or whether it was Shelley's attorney, but somebody notified the district court that a bankruptcy had been filed. Now, I know this is redundant information to the district court. So Shelley went over that day to court. She came back to my office and she said, the court just adjourned the hearing and they're waiting for the paperwork to be supplied to close the case. So I hand-filled out an administrative closure order, wondering why nobody had ever thought about this before, gave it to Shelley, she took it over and filed it, and that's why we're in your court. I think they waived jurisdiction, but frankly, all the stuff that happened in district court is irrelevant, basically. What we basically have here is we have an issue that she wants to stay in place longer to remove the stuff. We've been now a week short of 2 months. My understanding is she drives by the property 2 times a day, wants to take her kids to school and wants to come back from school. At this point in time, my client's paying $50 a day to keep somebody held up in a hotel, and there has not been, and admittedly in their pleadings, there's not been any adequate protection paid. And the case law is clear on this issue that when adequate protection isn't being paid and there isn't a long-term lease that has any benefit to the estate, that the stay shouldn't continue. At this point in time, Judge, the trustee has abandoned all interest in all of the assets, both the personal property, any interest in the lease, any interest in anything that was cited in the bankruptcy paperwork. They have, the trustee has filed a report regarding other assets that the trustee intends to look into, but not these assets. So, from my perspective, based on the report that the trustee filed, the trustee's abandoned his interest in the property. And I guess the question I'd like to ask at this point in time is, does the debtor concede that Shelley Sweet is the owner of the real estate?
Mr. Havens, are you looking at the trustee filed a report, it looks like on September 28th, with basically an inventory of assets.
I have it as document 24.
Right, the same document I'm looking at right now, Mr. Havens.
I'm looking specifically at lines 16, 32, that's it.
$32 is prepaid rent at the 829 East Walton. 16 is jointly owned with spouse, couch, 3 bookcases, and I suspect because of
length short.
Right, but the value in the petition was $2,500, and it's deemed as abandoned under 11 U.S.C. Section 554C. By looking at that line item for 16. As well as 32 contains the same notation as being abandoned under 554C. So that's your basis for the trustees already abandoned these 2 issues of property.
That is correct. I can shorten my argument, Your Honor, if I can obtain a concession from the debtor that Shelley Sweet is the owner of the property to the best of her knowledge.
When you say the owner of the property, you're talking about the real property at 829 Walton.
Correct, sir.
Very good. Well, let's find out if we can shorten the hearing or whether we need to go forward, Mr. Havens, unless you want to make some further comments at this time.
Not at this time.
Thank you, Mr. Havens. Ms. Honig, it's an interesting...
I would like to, if they would concede that, May I continue?
Sure.
Will you concede that issue?
I don't think anyone's disputing that she owns the property.
Okay, then under 362, Your Honor, the burden of proof shifts to them.
Well, let's, anything more, Mr. Havens?
No, because I believe I have established the only burden of proof I have to establish.
Ms. Hunter.
Thank you, Your Honor. I guess first of all, I'm not sure why the case took so long to be administratively closed, but I can tell you when I went to that state court hearing, I informed the court of the bankruptcy. I actually informed them of it prior to that date, and Ms. Sweet's attorney acknowledged that a bankruptcy was filed, yet they proceeded to enter an order that day. But in any event, I have a problem with this notice of intent to sell because the notice says that property in that house would be considered abandoned, and as far as I could tell in the rules, even if it's just a notice of intent to sell, there's supposed to be 14 days to object to it. So I don't think notice was sufficient, and I don't know why the creditor didn't try and get the stay lifted weeks prior to that because they were aware of the bankruptcy, but my clients just primarily want their stuff back, and at this point they are locked out of that house. They don't have any way to pick anything else up, and stuff was removed from that house on the day before that possession in the notice was said to take place. There was property taken out prior to that time. So my primary argument is my clients just want their personal property back. Yes, they claimed it exempt, so the trustee doesn't have an interest in it, but it's still their personal property.
Well, let me ask Ms. Hunter, Mr. Havens, where is the remaining personal property? It doesn't sound like there's much of a dispute about the land, the building, but it's the personal property that was in the building. Were all those things stored somewhere or thrown out on the curb or somewhere in between?
Okay, with all due respect, Your Honor, that's not the reason why we're here. Okay? We're here regarding stay over the real estate and being able to sell the house. The issue regarding the property, we have issues also, and I think it's appropriate to bring those up in a more proper way. What I understand happened was, now, I have not had detailed conversations with my client. What I understand happened was the lockbox was put on the house on, the realtor's lockbox was put on the house on July 1st, and on September 7th or early in September, there were some arrangements made to have an appraiser go on the property because of this pending purchase order. And the realtor went there, said there was nothing, in his report said there was nothing but junk left. During the interim time after that, until that Sunday morning at 7 o'clock, she hadn't even gone in the property, and it was her assumption that everything else that was left was junk. And my understanding is she called neighbors, she called anybody that wanted anything, but there was even after that stuff left because the police were there, and I talked to them on the phone. So I honestly don't know what happened with the stuff. I think some of it went when Shelley went in there, and a lot of it went way before Shelley went in there, and some of it went after Shelley went in there.
What's in there now? Anything?
In the house?
Right.
The house is empty.
Completely empty?
Completely empty, Your Honor.
The police asked me, Your Honor, to give them back the key, and that was the day before that hearing was scheduled in the district court. And I suggested to the police officer that this was a civil matter that should be handled in court, but he disagreed.
I'm sorry, Ms. Honig, we kind of cut you off in the middle of your statement, so go right ahead.
Well, I know my client, I don't remember what I was saying before, but I know my client had, I think last week, was it last week, last time you went over there?
And I went over there on a Monday and I think it was a Monday, and I was going to get another load of stuff. The house was locked. At that point, that's when I called the cops and said that we can't get in the house. The cops met us all there. The police did grant me the key. I asked the police officer if he would go in and make sure there was no damage to the house, because I saw Robert carry out a crowbar, and to make sure our stuff was not missing. He said he would not do it because it was a civil, not a criminal. At that point, we left, or he left. We went in the house and noticed that about 50% of the stuff that I still had there was gone. Now, when she says junk, I don't know how anybody can consider a love seat and couch leather with 4 recliners junk, and huge entertainment that holds a 52-inch TV is junk. I mean, her classification of what was left as junk is, I had a pink Aurora collectible dish set that was still there. I mean, it wasn't junk. There was a lot of items left, which we've included 3 pages of items. I had 8 bins of Christmas decorations still in the garage. Recently, we had an auctioneer come in and just kind of glance over the stuff. This was before she took anything. He said that after his fees, which run between $1,500 and $2,000, that there would still be about a $3,000 check that would come to us after the bankruptcy was done if we were to sell those items. So her classification of junk is a little misinterpreted there. But at this point, I went back. At that point, we got out what was left, except for I had not gone back and cleaned up. I had gone through some bags that she threw as garbage, and I needed to go back and clean that up and get some empty boxes. I went back, and all the locks had been changed again. So at this point, I'm not there, but a lot of some statements that Bruce has just said and some statements that I've seen in here are inaccurate, and he admitted to not really sitting down and talking to his client.
Ms. Honig, it sounds like your clients are much more concerned about what you and I would call the personal property versus the real property.
Correct, Your Honor.
And everything I've heard so far, I've seen the pleadings, really raises an issue of should Ms. Sweet should she have taken out the personal property as she did, and if she did it improperly, there'd be an issue of damages for the loss of that. On the other hand, Mr. Havens, on behalf of his client, raises the issue of probably have a pending sale for this property, 829 East Walton, that they just want to complete that sale. And so, in some ways, you're talking about personal property, Mr. Havens is talking about real property, and if there's no more personal property at 829 East Walton, there's very little that it seems to me that you can do about that today in terms of if it's gone, it's gone. And likewise, I can't do anything about it either. And if there's something more there that could be moved in a day or so, then that's a different story. And it looks like one of your clients wants to talk to you, so if you want to just take a short conference, but I'm just trying to figure out, is this a case where we should let the real estate be sold and then argue about the value of the personal property, what happened to it later? And if it should be later, should it be here or in state court, or where should it be argued? Because I see 2 different parties with 2 different concerns, and I would hate to have the Sweet adversely affected for no good reason. I hate to have your clients adversely affected for no good reason. So that's what I'm kind of puzzling over. Do you want to talk to your client just for a second? Because it looks like he's got something he may want to tell you.
Okay, sure.
You're welcome. Ms. Honey.
Your Honor, my primary concern with this was that the notice said that their personal property would be deemed abandoned, and that's the main objection, is their stuff would be deemed abandoned if this notice is considered valid. They don't necessarily have an objection to the sale of the real property, but they don't want their personal property considered abandoned.
Right, I understand that, and that's what I'm hearing from everything you're telling me, and what one of your clients has told me directly. I haven't heard anyone say, by the way, we want to buy this property, or we have a purchase agreement, or anything like that. It's basically, we're concerned about our personal property that's there.
Well, originally, we had an agreement for a lease to buy it, which
Right.
is why this has been drawn out so much, is that she just kind of went and sold it. I was making payments towards it. $400 of my monthly rent was to go towards the purchase of the property. But when she said, here, you need to buy it now, I don't have a means of buying it, obviously, right now. But if we would have carried out the agreement in 18 months, I would have had the means. And that's why, and then they file this notice. They only send it to the trustee and to her, who is not representing us in the eviction process. They didn't even send us a copy to say, hey, you've got 7 days to get your stuff out of there. So I don't, the possession of the property, one, they've already got it, two, they can have it, let them sell the house. But this piece of paper, this notice of intent to sell, is what took our property, and it should be brought back.
Right. When you say your property, you mean
My personal
your
stuff.
personal property?
Yeah.
Understand.
May I address that issue, Judge?
Let me ask Ms. Horn, anything more you want to say right now? Because we'll go back and forth for a little while longer. I can just tell that already.
No, Your Honor, I think you understand what our objection is.
Sure.
Thank you.
Mr. Higgins.
I mean, it's not that, hey, Judge, first time I've been to Flint, and you know me, I don't like coming to court.
Right.
It's not that you scare me or, I don't like to see you, but it's a waste of my time.
Well, when you said circuitous route, I thought, it is a different trip from Mount Pleasant to Flint.
It is, and Linda let me take her car, so I actually had some fun.
I see.
As far as the personal property goes, okay, there was never my intent to do anything other than get the house cleaned up so we could get it sold, okay? Mm-hmm. And what transpired regarding all of that, I mean, I would assume, when you compare what was on the petitions and schedules to the list, okay, the trustee may reopen the door to that too, because there was a 1-carat gold marquee ring, or diamond marquee ring, and a man's diamond ring, and there was all sorts of what appeared to be very valuable things that weren't scheduled. So maybe the trustee will reopen the issue on the personal property. All I care about is being able to sell this house. That's all I'm here for, and if that time comes to fruition, we'll have to deal with it. It's just the urgency of the matter is possession so we can sell it.
Mr. Higgins, what exactly do you want from the court in terms of, you want an order of some sort that says essentially that your clients have the right to sell the real estate at, I just lost the address, 829 East Walton Road, Mount Pleasant, Michigan? Is that
Yes, and that there's no stay in effect.
Would you have any problem with that order being signed by the court with an additional condition that issues regarding personal property, and we distinguish between real property and personal property, of the debtors will be resolved at a later date and time, because
Absolutely, no problem.
that would give your client the right to sell this property, and Ms. Horning give your clients the right to say, wait a second, you threw a lot of our good stuff all around the street, for lack of a better word, and whatever that means, because I'm not hearing that there's necessarily an objection to the sale, just that you want to protect that property right of your personal property, your client's personal property. And to me, that, if nothing more, at least let's stop one part of the issue here, and we can address, or the state court can address the personal property issue either by way of motion or adversary proceeding, however you want to go forward on it. in that way, it seems to me that the debtors can get all their evidence together. I mean, we've got a statement by counsel and by Ms. Sweet that there's nothing more there. So, I mean, even if I would say, okay, everyone give me your car and meet at 5 o'clock at this house and pull everything out, there's nothing to pull out. So we have to live with that unless something miraculously appears again. So that's what I'm thinking is let's have an order that allows for the sale with the understanding that 362 doesn't apply to the sale, but preserve all your rights to make claims for the value or conversion or whatever the case may be, either here or in another court. Ms. Honig, does that cover your client's concerns here today? And there'd be no issue that the personal property has been abandoned. That would be what I would see as the other issue that you're concerned about.
Yes, Your Honor.
I just want to address that. The abandonment issue for personal property, Your Honor?
Right. What I'm saying is that this order doesn't really address that issue whatsoever, and it preserves whatever rights you would have in this property, and they may be everything or they may be nothing. I'm not in a position to tell you that today because I don't have any proofs, but it certainly protects you as much as you can possibly protect today. Again, if the proofs were, if there was evidence that you still had your TV and the couch and a few things left there, I'd say, like I said, everyone get there at 5 o'clock with a truck to move this and let's move. But we can't do that because apparently it's not there anymore. So now we have to deal with what's the value of that one way or another. And we either do it in this court at a later date or you do it in another court in a later date. That's what I'm thinking right now, because you wouldn't know really what the value of some of your property is until you maybe, one, thought about what was there, and two, how much did it cost and how much did it cost to replace it. So there's an advantage for everybody, it seems to me, in that situation. So does that answer your question, sir?
So long as it's not deemed abandoned by the court, I guess it would be my biggest concern, because they're operating under the pretense that this document...
That's exactly the purpose of the language.
And Mr. Havens, that's exactly what you're proposing. Just let this real property be sold without any further ado, right?
Well, with one condition, Judge. If you ended up having to be a visiting judge down in Detroit, I'm sorry, Flint is as far south as I go.
I see. Now, by the way, the record should reflect we have this scheduled in Flint because of the time constraints, I think, both of the sale. And Ms. Horning, I think you were going to go on vacation or away for a few days, and so we put it here in Flint today. Future hearings would be held in Bay City unless there's something that I don't know about.
Well, I don't know, Ms. Sonic and I might get together and put you up in a room at the Soaring Eagle, and maybe we could find one of the courtrooms at the local court here for you.
Not too sure we're authorized to do that.
Can I ask a question?
Sure.
This form that Bruce filed, it actually gave his client permission, or says the intent to go in and take our stuff, and that's what she did. It was there. I mean, we'd be sitting here today saying we have stuff in the house to remove if she hadn't gone with what her attorney created. So, but I'm sitting here today saying that it's kind of being ignored that they took this stuff with this form and just were having an order until a later date. Meanwhile, who knows what she's doing with our stuff, so in the end, it may not even be there. I mean, we wait another 2 or 3 weeks, she could be selling it, giving more of it away. I mean, I guess that we got to this point because of hearing, and now it's becoming another issue. Leslie said the bankruptcy was, they knew the bankruptcy from the beginning. It was her other attorney, Nancy Gallagher, who canceled our motion to set aside the default. I just feel like it's, they kind of played in here, did a setting, didn't give us the right time to remove our possessions. And yeah, they want possession to sell the house, but I feel like we're still getting kind of robbed from our stuff, when he even admitted that he kind of went a weird way to make it happen fast, but in that weird way he didn't notify us that we only had 7 days to get our stuff out, and now the stuff is gone, and now the court's telling me that we need to wait and handle it a different way, but he handled it this way. I guess that's my confusion. I mean, I understand what you're trying to protect us, but I'm also feeling that he kind of went a quirky way, and now that piece of it's not going to matter today.
Well, see, how I kind of looked at this case, ma'am, is that on one hand, you had a lease for this property in Walton, and it appears that that lease didn't work out well for whoever, and that you had to leave the property. And second, Ms. Sweet, who owns the property, has someone who can buy it, and we have the sale on that. Now, that's one half of the coin. The other half, or the other side of the coin, is your personal property. And that, there's two issues here. First off, procedurally, it's not particularly well in front of me, because I think what Mr. Haven wanted to do was, and your attorney, Ms. Honig, out of an abundance of caution, protected you on this front. I think Mr. Haven just wanted to have it clear that the real estate could be sold, was not part of the bankruptcy estate. Ms. Honig did an excellent job of making sure that I know that there's also more to the story than just that, and that part of the story is your personal property and what happened to it. Because, as Mr. Havens has said, the bankruptcy was filed on August 10, and it looks like the complaint to evict wasn't filed until afterwards, and certainly the hearing on September 7th occurred after August 10. I mean, those are all facts that no one can argue about. And then the issue is that if you had things there that are no longer there, then someone needs to explain what happened to it. Now, from your standpoint, you've mentioned to me some, I think it was like a sofa, love seat, TV, other items, but I remember those three very clearly. That would strike me to be worth a fair amount of money. Now, Ms. Sweet would perhaps take a different view of that, and that's why I don't know what was there and what wasn't there. I do know from what's been told by everybody that there's nothing there now. And if the Ms. Sweet or someone under her control took that stuff, for lack of a better word, converted it, well, then she has to explain that to some judge sooner or later. And you want to be in a position to say, this is the laundry list of things that were there, this is how much I paid for, this is how much it's going to cost me to replace them, and that's what we call damages here. And that's what I'm trying to figure out is, what can we take care of immediately but still protect everybody else? Because at the end of the day, if you don't have an interest in the real estate, there's no reason not to sell it, if nothing more than to let Ms. Sweet have the money that she may need later on, and now I'm going to speak from your standpoint, to pay you some money, and that's what you'd want to have her have. So that's what I'm looking at here. It's going to be up to you and Ms. Honig to decide when do you want to bring that to the court's attention, how do you want to bring it to the court's attention. There are different ways of doing that. And I'm trying to make sure that whatever rights you have today in this property they aren't being adversely affected by that. So, Mr. Havens, first off, before I say anything more, ma'am, does that answer your question a little bit clearer? Do you understand, Judge Ritter?
Yes.
Mr. Havens, can you put together an order that, one, allows for the sale of this property, indicates that Section 362 is not applicable, and finally, however, that the court reserves for the debtors all rights that they may have as to the personal property, and that it's not deemed abandoned, at least for purposes of today?
Yes, sir.
And Ms. Honig, you'll want to take a look at this order?
Yes, Your Honor.
Right. When do you leave? Because I remember we had...
I actually leave Friday, but I had court tomorrow afternoon. That's why
Okay.
I'm being Bay City tomorrow afternoon.
I see. That was the problem. I remember there was a schedule issue. So, Mr. Havens, can you get that order over to Ms. Honig as soon as possible? Because she should take a look at this order before...
Yeah, I'll call my office before I leave here, and we'll have the hot off the press.
Very good. And if there's a problem with the settlement of the order, give us a call, and we'll do it by telephone if we have to tomorrow. But if we do have a problem with the settlement of the order, I want to see, one, the order, proposed order, as well as if someone can mark up what their changes they think ought to be, so that I have something to compare, and we'll go from there. So, Mr. Havens, anything further that you can think of that needs to be addressed?
No, Your Honor.
Ms. Honig?
No, Your Honor.
Very good, thank you. And,
But you are going to Detroit, right?
No, not
Okay.
Have a safe trip back home, everyone.
All rise.